It is good to see everyone. Hope everyone's caffeinated. I want to thank you, Sandy, for that introduction. And my thanks go to the Criminal Justice section of the ABA for inviting me here this morning. I think as judges and prosecutors and private defense lawyers and public defenders and advocates and academics, you all have an incredibly important voice to play in our criminal justice system, and it's really a privilege to be here with all of you. And it's great to see Jim Fellman, who I worked with on the Clemency Project for many years, but just to see some friends. So more than 200 years ago, this nation was founded on the sweeping ideals of fairness and justice and equality that are enshrined in our Constitution. And a core promise of our justice system is that in our country, all people, regardless of wealth or poverty, status or stature, color or creed, are entitled to a set of undeniable rights. It's to equal protection and due process under the law, to fundamental fairness, and to impartial justice. But these promises are also the foundational struggle of our country. It's really the eternal challenge to keep that promise and to make it real for everyone within our borders. Events, certainly over the last few years, have highlighted on a national stage that stark perception, and sometimes all too often the reality, that some lives are deemed less valuable than others in our criminal justice system. There have been highly publicized police shootings of unarmed Black men in the last several years that have resulted in no indictments and no convictions that have really helped to fuel this. But this divide also extends our treatment of marginalized individuals and communities in the court system. You all know the statistics. More than 2 million people are behind bars in this country, a figure that has grown dramatically since the 1970s. And according to a report by the Sentencing Project, African Americans remain incarcerated in state prisons at a rate of more than 5 times that of whites. And more than 60% of all inmates in county jails are defendants awaiting trial, many of them simply because they could not afford to pay bail. There was a time really not so long ago when criminal justice reform was viewed as a third rail in politics. But I would say there's been tremendous reform in the last several years. But at this time and at this moment in our country, we have our work cut out for us to maintain that momentum for reform. I think we are obligated to do so to fulfill the promise of our Constitution and to ensure that all communities in this country have access to a justice system that operates fairly and has the legitimacy of the communities that are most in need. I received actually my own crude lesson in the criminal justice system and the need for reform as a 26-year-old lawyer at the NAACP Legal Defense Fund when I was fresh out of law school, looking at a series of cases in a small town called Tulia in the panhandle of Texas, located right between Lubbock and Amarillo, population size 5,000. I want to tell you the story of what happened. This was back on July 23rd, 1999, when over 12% of Tulia's Black population was arrested on low-level drug charges. And the arrests of 46 individuals, 40 of whom were Black, 6 of whom were either white or Hispanic, but had romantic relationships with African Americans, had taken place in a pre-dawn raid by a team of police officers who were in full SWAT gear arriving in people's homes at around 4 a.m. The local sheriff had notified the local TV stations and had cameras stationed right outside of the jail as individuals were paraded in front, kind of in their pajamas, half naked, as any one of us might have been waking up. And then the morning news aired footage of these folks being paraded into the local jail, having been awoken from their sleep. And the local paper the very next day ran a headline that said, "Tulia streets cleared of garbage," and listed out the names of all 46 individuals with their addresses and their charges. Tom Coleman, the narcotics officer who was responsible for conducting an 18-month sting operation in Tulia, claimed to be so deep undercover in this town for the time that he was there that he had to write notes of these alleged transactions on his leg, and that's why he had zero corroboration whatsoever at the time that each of my eventual clients went to trial. There was nothing. There was no corroboration, no marked money, no video, no wire, no nothing that you would think might be associated with an adequately conducted drug sting. Meanwhile, this drug sting was funded. It was a multi-jurisdictional task force funded by the Byrne JAG grants at the Justice Department. It turned out that the district attorney had also suppressed evidence in the initial trials of Coleman's arrest, which had happened during the course of this 18-month drug sting for theft and abuse of official capacity on a job that he had had just prior to working in Tulia in a neighboring county. So initially, 7 of the 46 defendants tried to go to trial to establish their innocence, and swiftly, one after the other, was convicted and sentenced to extraordinarily long prison terms. At that time, Texas had jury sentencing, and the ranges sometimes were, everything from probation to 99 years and beyond. Joe Moore, who was the alleged kingpin of this drug sting, a 57-year-old hog farmer who lived literally in a shack, and if that's a kingpin, tell me more. He received a 90-year sentence for 2 counts of alleged sales of between 1 and 4 grams of powder cocaine. The others who went to trial received sentences ranging from 20 to 361 years. After that, the remaining defendants made the very rational decision, the decision I certainly would have made, to take a plea deal to avoid such lengthy prison sentences. And after these trials, and the Texas media had really heralded this drug sting, then State Attorney General John Cornyn gave Tom Coleman the Lawman of the Year award. I learned about these cases by watching a 10-minute documentary that had been made by the daughters of William Kunstler. I flew down to Texas and drove for hours on its flat highways, going from prison to talk to my clients. And I met with my clients' families who really displayed overwhelming courage in the face of daunting odds. Know that this was about 2 years after the drug sting had actually taken place, and just weeks after 9/11 as well. And I'm going to tell you just as an aside that I looked like I was about 14 years old at that time, and I can't, I know that the faces of my clients would kind of drop when they saw that I was their last chance and hope for justice. But I actually got some doors open for me in West Texas because people kept asking me, am I related to Dr. Sanjay Gupta at CNN? And so one day I will thank him for helping me diffuse my youth going into these homes, but I have yet to meet him. But I literally stayed up nights freaking out about whether I was going to miss habeas deadlines. Many of these clients were now in habeas, having had all of their appeals denied and thrown out. And I was literally panicked that I was in over my head, and frankly, I really was in over my head. I eventually assembled a pretty formidable team of lawyers from some white shoe law firms in New York and Washington, D.C. to work with me. And it took us what seemed like 2 very long years to bring justice to our clients. But by 2003, after a lot of hearings and investigations and kind of turning in the media, we kind of triggered national media to turn the story around and to tell the story of really what had happened in Tulia. This so-called drug sting, which had at first been hailed as a victory in the war on drugs, we were able to show what a grave injustice it had been. And Governor Rick Perry then pardoned my clients, and we obtained a $6 million civil settlement as a small way to begin to compensate my clients for what they had endured, many of whom had served over 4 years in prison by that point. So these exonerations were major victories for those who had suffered really grievous harm at the hands of our justice system. But in the context of the broader systemic issues and challenges that we face, Tulia in many ways just felt like this teeny tiny drop in the bucket. Because after all, these victories came at a time when the possibility for criminal justice reform felt quite bleak in our country. The United States, remember 2003, so the United States boasted the highest and still boasts the highest incarceration rate in the industrialized world. Our country at that time, and it hasn't gotten too much better since, but it comprised only 5% of the world's population, but a quarter of its prison population. And this was a time when, I will say, only a few and too few advocacy organizations, even within the civil rights space, were paying attention to what was happening in our criminal justice system. Texas was spending more money building prisons than funding higher education in the state. And Tulia was your typical small rural town in Texas where the manufacturing companies had left. There were prisons and jails all around, and that was the main employer. So I had one mother, Maddie White, of 4 of my clients, who was a prison guard, and all 4 of her children were serving out prison terms all over the state of Texas, and the irony of that was pretty profound. Politicians of both parties were criminalizing more and more things, and you know this, over a period of many years everything from substance use disorders to mental illness to school discipline and beyond were being criminalized, and the sentences just kept getting ratcheted and ratcheted up. So more people were coming in and serving much longer periods of time. And at that time, really, any efforts for reform were upstream with little momentum or consensus for reform. And we had hearings in the Texas state legislature after these cases trying to get reforms on requirements for corroboration for confidential informants, looking at Texas sentencing laws. I would like to think that these cases played a role in pushing Texas to become one of the first states to really undertake significant criminal justice reform in 2004 and 5. But it didn't look like that was going to happen at that time. And it was at this crossroads that I went to the American Civil Liberties Union, a place where I felt like the support of the affiliates at that time that we could really start to push for reform at the state level. We were starting to see, as I said, Texas was taking the first step, and some other states were beginning to follow suit in red states, right, driven by the need to balance budgets primarily, but starting to really talk about being smarter and not just tougher about crime policy, and to try to use evidence to drive policy and not just politics. And at the ACLU in 2010, we launched the Smart Justice campaign to advance broad-based criminal justice reforms while protecting public safety. I worked with progressives, I worked with conservatives. At that time, the group Right on Crime was beginning to form. We leveraged the kind of bipartisan work that we were seeing happening in Texas to advance reform in other red and blue states. And it was also during my time at the American Civil Liberties Union that Attorney General Eric Holder announced his Smart on Crime initiative. And that really felt like an incredibly important moment in this country, a watershed moment to have the nation's chief top law enforcement officer, who had been a federal prosecutor for many years in D.C., it really felt like a game changer for the federal system. That initiative directed federal prosecutors to take a targeted approach, reserving the harshest of those penalties for the most violent and significant drug traffickers, and to use their discretion not to seek mandatory minimum sentences for lower-level nonviolent offenders. And there were a list of criteria that had to be met for prosecutors to be able to exercise that discretion. I was also fortunate to partner with the ABA, as I mentioned, and with Jim and some others, after President Obama announced the beginning of the Clemency Initiative, an initiative that I believe the ABA should be so incredibly proud to have been a part of, because its accomplishments and legacies and lives touched have been profound. I was also proud then to join a Justice Department that was committed to protecting public safety while reforming the criminal justice system, that understood why both were necessary, and really following the leads of states around the country. I joined in October of 2014, just a week after a police officer had killed Michael Brown in the streets of Ferguson, Missouri, and where, as all of you know, massive unrest ensued not only in Ferguson, but really around the country. And every week that I was on the job for the almost 2.5 years that I was there, it seemed there was a new video of police violence that was kind of racking the nation. From Seattle to Cleveland to Baltimore to Chicago, the Justice Department's police department investigations highlighted the breakdown of police community trust that led residents to see the justice system as illegitimate and authorities as corrupt in too many places. And these perceptions really drove resentment. It didn't just drive resentment. I mean, we had investigations that were revealing victims and witnesses refusing to talk to the police in certain neighborhoods in these cities and having a real impact on the public safety mission of police officers. The resentment was preventing the type of effective policing needed to keep communities and officers safe. And this was a moment when the federal government played an important role in voicing and really validating the experiences of low-income communities and communities of color in the criminal justice system, but in also seeking sustainable solutions in some of the most vexing challenges in fair policing in our cities. In Ferguson, Missouri, our investigation of the police department and of the municipal court shined a national spotlight on the intersection of poverty, policing, and injustice. In addition to blatant discrimination against African-American residents that we obtained through emails by local officials, really terrible, horrible stuff, we found the city was actually using policing as a means to generate revenue and funding its local court system off of the backs of African-American residents and low-income residents. The city was routinely issuing citations with excessive fines and fees for minor violations. Fines like $302 for jaywalking, $427 for disturbing the peace, and $531 for allowing high grass and weeds to grow on your lawn. The municipal court was open 2 days a month, and those days would change without warning or notice to residents, so you can imagine also the frustration when people were leaving jobs to try to pay these. When people living in poverty couldn't pay these fines and fees, they were arrested, jailed, and faced payments that far exceeded the cost of the original ticket. And these practices broke the law and degraded residents. They had destroyed the trust between government and residents long before Michael Brown had been killed. Let me just tell you that these practices, and probably many of you know this, are hardly confined to Ferguson alone. They are happening all over the country, and they are happening today. I was just in Knoxville, Tennessee, where I heard about local practices in Tennessee around the criminalization of poverty through fines and fees. In response to the pervasiveness of this problem, I issued, along with Lisa Foster, who was the director then of the Access to Justice program at the Justice Department, we issued a Dear Colleague letter to state and local judges after a series of meetings with many of the stakeholders on these issues. And it was an effort to address some of the most common practices that run afoul of the Constitution and other federal laws, such as incarcerating individuals for non-payment without determining their ability to pay. The letter also addressed other key issues in the enforcement of justice system financial obligations, including the importance of due process protections, such as notice, in inappropriate cases, the right to counsel, the need to avoid unconstitutional bail practices that result in punishing individuals for their economic status rather than for crimes that they may have committed, and due process concerns raised by certain private probation arrangements. We also filed a brief in a suit challenging another unlawful justice system practice, the automatic suspension of driver's licenses of those who fail to pay court fines and fees. Taking away a person's driver's license without due process or any inquiry into their ability to pay can obviously lead to a vicious cycle of poverty and entrenchment in the justice system. It isn't just that it's unlawful, it is bad public policy. So from police reform to bail reform and fines and fees to access to counsel and courts to sentencing to juvenile justice and the school to prison pipeline to solitary confinement, we did what we could aggressively to enforce our nation's civil rights laws and ensure justice for all. That is the mandate for the Civil Rights Division at the United States Department of Justice. We understood, too, that trust and fair treatment are vital pillars for public safety in communities all over the country, and momentum was on our side. And that is why I won't deny that in so many ways I feel a pretty acute sense of whiplash right now from the last administration to this one. I have been heartened to see, of course, a more public health response to the current very terrible opioid crisis that is gripping the nation. But it goes without saying that we are in a very different place in Washington, D.C. today. This administration and this Attorney General have quite swiftly rolled back many of the reforms aimed at building a smart and more just public safety system. There is a real concern about the promotion of discredited 1980s criminal justice policies that ignore the evidence we now have about effective criminal justice and how to get this right. I want to just list off a few notable changes. You all have heard and know about them. The withdrawal of Attorney General Eric Holder's Smart on Crime initiative in favor of prosecutors charging the most serious readily provable offense, withdrawal of a memo setting a goal for ending the department's use of private prisons, the end of a program that was aimed at banning a very limited number of military-grade weapons from our police departments while mandating training and some parameters about how other pieces of equipment should be used, reversal of reforms to the federal civil asset forfeiture program, retreat of police reform in favor of so-called local control. And let me just say, there is no question that policing is fundamentally local. But we also have a constitution and federal civil rights laws enacted by Congress that give the Civil Rights Division the mandate to investigate patterns and practices of unconstitutional policing. It was a power that was used very judiciously in a country with 17,000 police departments. The Obama administration opened 25 investigations and was enforcing 15 consent decrees by the time that I stepped down. Even the COPS Office Collaborative Reform Program now has been essentially gutted. It relied on a voluntary partnership between law enforcement, the city, and the Justice Department to analyze and remedy policing problems that has been effectively ended. And we are watching now, and I know you're going to be having a panel on all of these issues, how immigration policies are impacting the U.S. criminal justice system, from policing to detention to corrections. But despite what's happening here in Washington, D.C., the reality is that states are continuing to lead the way on criminal justice reform. And we continue to see states like California, Louisiana, Oklahoma, New Jersey, and Georgia, and beyond, enact really important criminal justice reform. Around the country, a broad-based movement of people of all backgrounds across the political spectrum, from defense counsel to prosecutors to policy advocates to faith and business leaders to activists and people directly impacted by the system, people are pushing for reform and winning. The work really that is being forged right now in red and blue states alike is having an enormous impact. The work to end discriminatory profiling and mandatory minimums and cash bail, thus to stop funding local court systems off of low-income individuals and people of color through fines and fees, to push for meaningful support for the defense function, to eliminate collateral consequences and promote reentry policies to keep people from returning to prison. I am not naive, though, about the Justice Department's immense bully pulpit and funding streams and how they impact state and local criminal justice systems. But the work to end mass incarceration and eliminate racial bias in the criminal justice system at the state and local level, I believe, remains very alive and well. I spoke last week, actually, at the International Association of Chiefs of Police conference. And it was attended by several thousand of the nation's chiefs. And their agenda, really, if you look at their program, was continuing to focus on the tough issues like de-escalation, procedural justice, proactive policing that protects communities. Many chiefs understand all too well that this issue doesn't go away from political administration to political administration, and that a breakdown in trust between police and the communities that they serve is only going to hurt public safety. Indeed, about 2 weeks ago, also, over 200 current and former police chiefs, federal and state chief prosecutors, and attorneys general from all 50 states met in Washington, D.C. as part of a group called Law Enforcement Leaders to Reduce Crime and Incarceration. And per their official language on their website, they believe that the goals of reducing crime and reducing incarceration are not only compatible, but they are mutually necessary. They say, we believe unnecessary incarceration is counterproductive, as it can create more crime, waste taxpayer dollars, and further divides law enforcement from those we seek to protect. So in closing, I'm really proud to lead the Leadership Conference on Civil and Human Rights. It's a coalition of 200 national organizations. We have a staff of 50 that remains committed to working collaboratively with all stakeholders to advance smart criminal justice reform around the country. And the Leadership Conference was started 67 years ago by Jewish and African American leaders who recognized that the fight for civil rights couldn't be won by one group alone, and that really would have to be waged in coalition across communities. The Leadership Conference was for many years the federal arm of the civil rights movement, having helped to craft and shepherd through the Voting Rights Act of 1965 and all major federal civil rights legislation since. And increasingly, we've been working in the states as well, working to close that justice gap and make America as good as its ideals. We all know that the work we do to close the gap between this country's lofty ideals and people's actual lived experiences is never easy, particularly when it comes to criminal justice reform. It never has been, and it never will be. The march is always uphill. The history of our country's progress has not been linear, but the nation's progress, I will say, has also not been inevitable. Our values and our Constitution and our democracy, they do not protect themselves. Our progress has been as a result of people pushing, sometimes inside government, but many times outside, on the streets, in the courts, in the media, in state legislatures, and in Congress, when there's hope. This work, I think, has always required a profound reservoir of hope, and it's often in times of challenge that we find our strongest voice, our solidarity, our power to fight hardest, and most effectively, to preserve the rule of law, to protect the vulnerable, and to make justice real. And so I just want to thank all of you as members of the American Bar Association for what you do every day to bring us closer to ideals and for continuing to understand that public safety is not just the absence of crime, but it is also the presence of justice. So thank you.